I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class. Okay. I know how to analyze the law. What fool's going to pay like almost $3,500 a night? You don't follow what the court says. You don't follow what anyone says but you. You didn't have the money. You literally just said on the stand, stop.
I have a credit card.
Stop.
How would I make
Go up to jail.
Platforms like VRBO let people earn side income by renting out their homes. But in most places, that only works if you follow local and state laws. And that's exactly what Carl Olsiums, a property owner in Burnett County, Wisconsin, tried to do make extra money, except he didn't follow the rules. After neighbors complained about repeated short-term rentals in a residential area, they filed a nuisance case against him. And on October 4, 2024, Carl appeared before Judge Mogan, who ordered him to stop renting the property unless he first obtained a Wisconsin Department of Agriculture, Trade and Consumer Protection tourist rooming house license and a Burnett County rental permit under the county ordinance. When Carl didn't comply, the court brought him back for a contempt hearing in 2025, where he was given a clear chance to fix the violations, follow the order, and avoid jail. Instead, Carl went right back to renting the property, charged guests for full stays, and then claimed most of the nights were free to justify what he was doing. And now, on February 6, 2026, he's standing in front of the same judge again, representing himself, still arguing his own version of the law and facing the consequences of ignoring the court's orders. Let's see how this ends.
We will go on the record in the matter 23 CV86, Rick Brimacone et al. Versus Carl Olsiums et al. Appearances are, we have parties appearing here today. Carl Olsiums appears in person without counsel. We do have Rick Brimacone appearing with counsel Christopher Anderson. I'm not sure which others of the plaintiffs do appear here today for the hearing. They're not required to appear, but we do have the lead, Mr. Brimacone, with Mr. Anderson. We're set here today in this matter for the plaintiff's motion against Mr. Olsiums as it relates to a contempt, and the court will take up Mr. Olsiums. I think you filed a motion to stay the court's order unless you are not continuing to seek that.
Yeah, well, it's under appeal, and I just filed a motion to basically stay everything until the Court of Appeals rules.
Right, so I will hear that motion,
Right.
But it's not an automatic stay. It doesn't.
No, I know, that's why I'm.
But yeah, I will hear that motion, and that is exactly why we needed to have this hearing timely. Off the record, the court did inquire as to whether or not anyone was requesting sequestration of witnesses. It was told to the court that no one is asking for sequestration, correct, Mr. Anderson?
We are not, Your Honor. That's correct.
Correct, Mr. Olsiums?
Correct.
Okay, so I do not have to sequester witnesses. Therefore, Mr. Anderson, I will take your motion up first, and then I will move on to Mr. Olsiums.
Yeah, simply put, Your Honor, there's an order from the court requiring Mr. Olsiums to get permission from the license from DATCP, along with an order from the court of October of 2024 that requires Mr. Olsiums to not rent his property unless he has the proper permission and licensure from the state and the county. He is, by his own admission, he does not have that and has never applied for it as far as I know. Last summer, in the affidavit of Rick Brimacone, it's also outlined that there was 5 different periods of rental. And we can go through the specifics of that in testimony, but there was 1 in May, 1 in June, 1 in July, and 2 in August, all in violation of the court's order. And so therefore, Your Honor, the court's order was violated again, and it was already violated previously by Mr. Olsiums. And so we are asking for a finding of contempt and appropriate sanctions relating to that contempt.
All right, thank you. All right, Mr. Olsiums.
In response, the order doesn't say I need a license. The order says permission of the county, and the ordinance says it's 10 days or less. And it's my intention to rent the property for 10 days.
All right,
And that's what I'm claiming I did.
all right. The order says what the order says, and I'll have to interpret my own language in my order when we get to that. But Mr. Anderson, please call your first witness.
Call Carl Olsiums. Mr. Olsiums, you rented property in Burnett County over the summer of 2025. Is that true?
Yes,
Okay, and you rented that property May 24th through May 26th. Is that accurate?
I don't recall the exact dates.
Okay, you recall renting it over Memorial Day weekend?
I do, yes.
Did you rent the property in June of 2025, June 6th through 8th?
Again, I don't recall the exact dates.
Okay, do you recall renting the property in June?
I don't know specifically.
Okay. Do you recall renting the property in July?
Yes, I do.
Okay, and that was to a James Bennett, true?
Yes,
Okay. And you rented that property from July 19th through July 26th?
I don't recall the exact dates, but I have the rental agreement there as an exhibit.
Okay. Were they there for approximately a week?
I believe so, but again, I don't recall the exact dates.
Okay, you think that would be on your rental exhibit?
It's on the rental agreement, yeah.
Okay. Do you recall renting your property in August of 2025, August 8th through the 15th?
I don't. No, I don't know. I don't recall.
You don't know the exact dates again?
No.
Okay. But you did rent it in August to some group for approximately a week again. Is that accurate?
I don't recall.
You don't know if you did that or not?
No. Mm-hmm.
Mr. Alston, did you rent your property out from August 28th through September 1st of 2025?
Is that the Labor Day weekend?
I believe that is Labor Day weekend.
Yes, I did.
Okay. Do you remember who you rented that to?
I don't remember the person's exact name, no.
I've put in front of you something marked as Exhibit 1. Do you have that in front of you?
Yes.
Okay. And do you recognize or do you know what this is?
I don't know.
Okay. I've just handed you what's also been marked as Exhibit 2. Do you recognize that?
Not specifically, no.
Okay. You see where it says inbox, Northwoods Heaven on Island in beautiful Northwest Wisconsin?
Yes.
Okay. It says we headed out of yesterday around 6 a.m. Excuse me. Do you see where it says that?
Yes.
Okay. It appears to be a communication to you. Do you agree?
Yes.
Do you recall receiving that communication?
Not specifically, no, but this is the communications portal in VRBO. So,
Okay. And that's the platform that you use to rent out the property?
yes.
Okay. From what you can tell, was a communication from Robbie. Do you see that down below in the main body?
Yes.
Okay. And is it Robbie Lang? Is that who you rented the property out to in over the Labor Day weekend?
Again, I don't remember the specific name.
Okay. Would you disagree with the affidavit that Mr. Lang filed in this case, that he rented it over Labor Day weekend from you?
No, I testified that somebody did. I just don't remember his name.
Okay. Your Honor, we will offer Exhibits 1 and 2 as communication through VRBO that Mr. Alsiums had either with the platform or Mr. Lang.
All right, then Mr. Olsium's asked to Exhibit 1, Exhibit 2. He is requesting the court receive them. Any objections?
No.
Received.
Whoever rented the property over Memorial Day weekend, you charged them to rent it from you, true?
Yes.
Okay. Do you recall how much?
I don't know.
Whoever rented it from you in June, though, you charged them rent. Is that true?
I don't remember renting it June 6th. I don't remember that. I don't recall that.
Okay. July 19th through the 26th, you charged those folks to rent it from you?
Yes.
Okay. And same with August 8th through the 15th, you charged them to rent it from you as well?
No, again, I don't recall that date or that time.
Okay.
Do you just not recall the August one, or are you saying you don't recall the July and the August one?
I don't recall the August one. I recall the July one, but not the August one.
Okay, thank you.
I don't recall the June rental, and I don't recall the August rental. I do recall the Labor Day, Memorial Day, and the July rental. The July rental, I have the rental agreement as an exhibit, which I'll show the court later.
Okay.
Okay,
Anything else you want me to know off of his questions?
that's it.
All right, thank you. You may be seated. All right, Mr. Anderson, next witness.
Call James Bennett.
Mr. Bennett is on yes, there you are. You are physically on the Zoom.
Mr. Bennett, please state your name, spelling your last, please.
James M. Bennett, Bennett.
And where do you live, sir?
I live in Rockford, Illinois. Would you like my full address?
That's fine. Did you rent property in northern Wisconsin in July of 2025?
Yes.
Okay. And do you recall renting that from Carl Olsiums?
Yes.
When you rented it, did you go through a internet service, VRBO?
Yes.
How long were you and your group at the property in July of 2025?
We were there from July 19th until July 26th.
Okay, so you're there 7 nights?
Correct.
And how many were in your group that stayed at the property?
There were 14 of us.
Do you recall how many vehicles were up there?
There were 5, I believe.
Any recreational vehicles of any sort?
We did bring our boat, which was parked on the water at the dock, and it was put in at a public launch point.
Okay. What was the purpose of your trip to northern Wisconsin that day or that week?
It was our yearly family vacation.
Do you know how much you paid for that rental?
Yes, I have it in front of me. The total was 6,000.
Yeah.
Mr. Bennett,
Oh,
Yes.
hold on, Mr. Bennett.
I have to give you direction because witnesses aren't permitted to testify using their documents. You may refresh your recollection as to what you paid. Once you refresh your recollection, please not look at the document and let me know or answer the question.
So, Your Honor, I have exhibits for I have one exhibit at this point in time for Mr. Bennett. I've provided it to him in advance, and I have copies for everybody here. I had the one marked by the clerk. Obviously, he doesn't have that one, but
That's fine.
is that all right?
Yes.
All right.
All right, Mr. Anderson.
Thank you, Your Honor. Mr. Bennett, you began to talk about a document that you may have been looking at. In the upper left-hand corner, is there a VRBO emblem?
Yes.
Okay, and then does it say get the app, USD, and some other words?
Yes.
Okay, and below that, does it say pricing?
Yes.
Okay, and at the bottom of the page, there's a heading that says booking made easy. Is that on yours?
Yes.
And in the middle of the page, it says price details, and then it goes through a price and has payments, payment 1 paid, and it has a number there. Do you see that?
Yes.
Is that what you were looking at to refresh your memory?
Yes, it is.
Okay, Your Honor, he has Exhibit 3 in front of him. I would submit to the court.
All right, any objection?
No.
Received.
Mr. Bennett, in looking at Exhibit 3, it says $6,950.48. Is that what you paid?
Yes, it is.
Okay, and that was to stay at the property for 8 days and 7 nights. Is that accurate?
Yes.
Mr. Bennett, when did you book, or how far in advance did you book your reservation at this property on VRBO?
If memory serves, it would have been about 7 to 8 months.
And then looking at Exhibit 4, it says booking confirmation and then rental agreement. Do you know how you received this document?
Yes, we received a link to it in the VRBO messaging app, the VRBO messaging app.
Okay, and do you remember when you received this document?
Yes, we received it the night before our vacation started, about 5 or 6 p.m.
Okay, and so that would have been July 18 of 2025?
Correct.
Okay. And when you received it, first of all, when you received it, did you look at it? Did you read it? What did you do with it?
Yes, I looked it over and then signed it.
Okay. And was it requested that you send it back somewhere?
Yes, it was. Carl Alsiums requested that we sign it and send him a confirmation.
Okay. At some point in time later that day, did you look at this booking confirmation rental agreement again?
I did, after my wife brought it to my attention that he had showed that part of the stay was complimentary and that we actually only paid for 2 days and that the rest was complimentary. She brought that to my attention and then I looked it over again.
Okay. Did that give you any concern?
Yes, actually a great deal. We were concerned that he may have been trying to leave himself an out to force us to leave early. Our thought was that maybe he had double booked it and was giving himself a reason to evict us early.
Okay. Ultimately, you were able to stay for the entire 7 nights, 8 days. Is that true?
Yes.
Yeah. Would you have paid nearly $7,000 for a 2-night rental?
No.
Okay. Your understanding was that you paid for 7 nights, $7,000 almost for 7 nights and 8 days. Is that correct?
That is correct.
Your Honor, we'll offer Exhibit 4.
Mr. Olsiums,
No objection.
it is received.
No further questions of this witness, Your Honor.
Mr. Olsiums, questions?
Just a couple.
Okay, you may proceed.
So can I call you Jim? Is that okay?
Yes, that's fine.
So Jim, you paid VRBO directly, correct?
Correct.
And looking at the pricing, you paid a service fee, which, by the way, do you know what a service fee is on Exhibit 3?
I guess I assumed that it was a fee paid to VRBO.
Okay, so that's not money that went to me, correct?
Objection.
I don't know.
That when-
Objection.
When there's an objection to all the witnesses who will be testifying, somebody says either Mr. Olsiams or Mr. Anderson says objection, you need to stop talking so that I have an opportunity to rule on that objection. So the answer or the question was, if he knew what that service fee was and that it did not go to Mr. Olsiams or something to that effect. I could read word for word if I need to, but that is an effect of what was asked. You objected.
Foundation and speculation is the objection.
Any response?
It's not speculation. He's the one that made the payment. He knows what he's paying for.
Well, that's not a legal argument. It is sustained. So you have to build a foundation for that information to come in.
So-
or the relevance.
Well, the relevance is that,
I'm not
Okay.
having you argue that to
Okay.
me. I'm just saying that in your questioning to Mr. Bennett.
okay. So Jim, is it your understanding that that money was to go to me or to VRBO? The
Are
service
you
fee?
specifically asking about the service fee?
Yes. Is it your understanding that was to go to me or VRBO?
Objection relevance, Your Honor.
Sustained.
The tax, the next item is tax. Was your understanding that was to go to me or to the local governing authority?
Same objection, Your Honor.
Sustained.
You testified that it was, you stayed 8 days and 7 nights. Isn't it correct that you stayed 7 days and 7 nights?
I think that that would depend if we count the day that we packed up and left that morning. If we count that as a day, then we were there for 8 days. We left the premises by 11 o'clock that day, but we were there at least part of that day.
Your Honor, I'll object. This is argumentative. It really is an argument that he's trying to make, and it's not a fact. He was there from July 19th through July 26th. How we count the days is an argument, not a fact.
Okay.
Sustained.
So Jim, you checked in before 4 PM on July 19th, correct?
No, we checked in at 4 p.m.
Okay, on July 19th.
Correct, on July 19th.
Okay, and when did you leave the property? What time and day?
He's already answered. July 26th, 11 a.m.
Okay.
Sorry. I wasn't going to wait for an objection to ask an answer.
Did you pay a damage deposit?
Objection relevance.
Sustained.
And did you cause any kind of disturbance at the property?
Objection relevance.
Sustained.
Were the police called to the property at all during your stay?
Objection relevance.
Sustained.
No further questions.
Redirect.
None.
All right. Thank you, Mr. Bennett. You are released. Unless I have any inclination that we may need him for a rebuttal witness, but I guess you would be able to contact him if we do need him, correct?
Yes.
All right. You are released. Thank you, Mr. Bennett. Next
welcome.
witness.
Your Honor, we call Debbie Tate.
First, it's Debbie Tate, Debbie, Tate, Tait, correct?
Correct.
All right. Thank you.
Thank you, Your Honor. Ms. Tate, where do you live?
I live in Prior Lake, Minnesota.
Okay. And did you rent property in northern Wisconsin in May of 2025?
Yes,
Did you book your reservation through VRBO?
yes,
And are you aware of who the owner was at that time?
yes,
And was that Mr. Olsiams?
yes.
How long were you and your group on the property in northern Wisconsin?
2 days.
Okay. May 24 through May 26?
Well, I guess technically 3 days if we're going to do that. Yeah.
And I don't really care about that too much, but 2
Yeah.
nights? You
Yeah.
stay there 2 nights?
2 nights, correct.
Okay. How many were in your group at the property?
There was 12 total, one night, and one night there was 10.
What was the purpose of your trip up north?
We brought side-by-sides up and we went on local trails in Wisconsin. My mom is very sick with dementia, so we just had a family. It was me and my siblings and my parents. So it was just a quick family getaway.
You said you went on trails. Did you have many vehicles or ATVs up there?
Yeah, we had, I was trying to remember, we had at least 5 vehicles, probably 6 when we had 12 people there. We had 6, plus we had trailers with side-by-sides on them. Probably, if I can recall, we had 5 side-by-sides, so 5 trailers.
Ms. Tate, do you recall how much you paid for the rental in northern Wisconsin?
Yes,
How much was that?
$2,864.33.
Okay. And you paid that through VRBO, correct?
Yes,
Your Honor, we will offer Exhibit 6.
Mr. Olsiams,
No objection.
received.
No further questions.
All right. Questions, Mr. Olsiams?
Okay, Ms. Tate, you testified that you paid $2,864.33. Is that correct?
yes, that's correct. Sorry.
And how much of that were fees going to VRBO?
Objection relevance.
Sustained.
And of the 2864.33, what was the amount that went as a service fee?
Same objection.
Sustained.
And how much went as a tax?
Same objection.
Sustained.
No further questions?
All right, thank you. I'm just gonna direct all parties that the issue here is contempt and renting the property. It has nothing to do with the value you received, the total amount of dollars. So if there's any confusion there, or unless I'm missing something, Mr. Anderson, it's the nights rented, not the dollar amount, correct? That could go into any argument, but it's whether or not the Burnett County ordinance was violated and/or state.
I think it's whether your order was violated.
And my order, same,
Well, the
Yeah.
contempt piece.
right, I'm going with what what
Okay.
Mr. Olsiums is arguing versus my
Okay,
order,
fair enough.
right,
Can I speak?
yes. Well, just why are you
Relates to this.
arguing?
Well, what he's gonna ultimately argue is that he's gonna try to get the money that was paid to me. So if, for example, if $8,000 was paid and I only received 5, he can't argue that he should get 8 because I never received 8. So that's why I'm going into,
Well, I understand your argument, to what money went
That's why
somewhere
I'm
else
asking.
versus what went to you. It's not relevant.
okay.
Mr. Anderson, did you have redirect?
No.
All right, Ms. Tate, you are released. Do not need to continue to stay unless you wish to do so. Otherwise, we're good to go. Next witness.
Thank you, Your Honor.
Call Rick Brimacombe. Mr. Brimacombe, please state your name, spelling your last.
Richard A. Brimacombe, Brimacomb,
And where do you live, sir?
in St. Louis Park, Minnesota.
You're one of the plaintiffs in this matter, is that true?
Yes, sir.
Okay, you've testified before in this overall lawsuit, is that true?
Yes, sir, multiple times.
Do you own property near or next door to Mr. Alsium's property in Burnett County?
Yes,
Were you at your property during the summer of 2025 on different occasions?
yes.
How much time would you say you spend up in Burnett County in the summer?
Close to 100%.
Okay. When you were at your property in Burnett County, did you notice people coming to the Alsium's property that were not the Alsiums?
Yes.
Okay, and do you recall how many times you observed that?
These 5 times.
Okay. Did you ever contact any of the individuals that were at the Alsium's property in the summer of 2025?
Yes, I spoke to them, yeah.
Mr. Burdick, I'm showing you what's been marked as Exhibit 7. Do you recognize this document?
Yes,
Okay, and are these pictures of one of the times when individuals were at the Alsium's property?
yes,
Okay, and these are pictures that you took?
yes,
Okay, and I'd turn your attention to pages 3 and 4.
yes,
That appears to be North Memorial Ambulance.
yes.
There's 2 pictures of that. Was it your understanding that an ambulance was called to the Alsium's property that weekend or that time frame?
Yes.
Okay, and do you recall which time frame this was?
That was what time these pictures were?
I'm sorry, which dates? Was that the May date, the June date? Do you recall?
I believe it was the May date. No, sorry, the June date, the second weekend.
Okay, the May date being what Debbie Tate just testified to,
Yeah.
her.
Yes, it was not Debbie Tate's weekend.
I would offer Exhibit 7.
Mr. Olsiums,
Objection.
received.
Do you recognize that document?
Yes,
And these are pictures, again, of people at the Alsium's property that were not the Alsiums. Is that accurate?
yes,
Okay, and actually, they're not people, but they're vehicles that you took pictures of?
yes,
Okay, and appears that some of the license plates are from Illinois. You heard Mr. Bennett testify that he's from Illinois. Was this the weekend of Mr. Bennett's group being at the property?
I believe so, yes.
Your Honor, we offer Exhibit 8.
Olsiums,
No objection.
received.
Perfect. I'm showing you it's been marked as Exhibit 9. Do you recognize this
Yes.
set of pictures?
Yes,
Okay, and it appears to be 3 pages.
yes,
Again, pictures of vehicles on Mr. Alsium's property when people were there that were not the Alsiums. Is that accurate?
yes.
Okay, and do you recall what time frame this exhibit was on?
I'm sorry, I don't remember exactly which weekend this was.
Fair. If your affidavit said that these pictures were taken during the week of August 8th through the 15th, would your affidavit be accurate?
Yes, took these pictures with my phone, so they would have had dates on the pictures.
Okay, and the information you provided for your affidavit would have come from that?
Yes,
Okay, so you think this was probably the week of August 8th through the 15th?
yes.
Okay, Your Honor, we offer, I don't know if I offered Exhibit 8, but I offer Exhibit 8 and 9.
8 was received.
Okay, thank you.
Mr. Olson,
No objection.
received.
Mr. Brimacombe, showing you what's been marked as Exhibit 10. Do you recognize that document?
Yes,
Again, pictures of individuals, or I'm sorry, of vehicles at the property that you took in the summer of 2025. Is that accurate?
yes.
Okay. And do you recall which time frame this was from?
I'm sorry, I don't.
Okay. Again, if your affidavit said that it was over the Labor Day weekend that this picture was taken, would you believe that to be true?
Yes, as I took the picture with my phone, which would have the dates, yes.
There. Your Honor, we offer Exhibit 10.
No objection.
Received.
Mr. Brimacombe, I've handed you Exhibit 11. Again, pictures of vehicles on the Alsium's property. Is that true?
Yes,
Okay. And there appear to be recreational vehicles, trailers, ATVs, things like that. Do you see that? Consistent with what Debbie Tate testified they brought up to the property?
yes,
Okay. And do you believe that this to be the weekend of Memorial Day 2025?
yes.
Your Honor, we'll offer Exhibit 11.
Mr. Olson,
No objection.
received.
No further questions.
Mr. Olson, questions?
Mr. Brimacombe, did you ever witness or see a rental agreement during the summer?
No,
Did you ever witness somebody giving me money for a rental?
no.
No further questions.
Any redirect?
No, Your Honor.
You are released. Thank you. Next witness.
That's all I have.
No more witnesses.
No more witnesses.
All right, Mr. Olsiums, do you have any witnesses other than yourself?
I don't.
Mr. Olsiums, this is your time and your time to give me all the information that you wish to give me, all the testimony you wish to give me as it relates to Mr. Brimacombe and Mr. Anderson's motion.
Mhm.
Mr. Olsiums, you may begin.
Well, very briefly, Your Honor, the order that you wrote does not say that requires a license from the county.
Well, let me read what my order says.
Okay.
Words are words, and I used words. Order said, the court finds that the plaintiffs have met the burden of proof and that there is no genuine issue as to a material fact. The facts asserted by plaintiffs are not refuted by fact or evidence and are so clear and convincing to the trier of fact that there is nothing left to establish. As such, the court hereby issues a permanent injunction, that's in all caps and bold, until such time Mr. and Mrs. Olsiums comply with and receive the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. That's what the court said.
My understanding of the order in conjunction with the county ordinance says that 10 days that I can rent the property for 10 days or less without any kind of county permission, license, anything. That's what the county ordinance says, and I believe that's what the right to rent state law makes a reference to that as well. So under that understanding, again, your order has to be in conjunction with the ordinance. So,
No, it doesn't.
well, if the ordinance says something, you can't change the law.
That can be your argument. I will tell you what I can
Okay.
do as a judge when I'm going to make my decision. I will stop.
Right. Well, the ordinance says that I can rent for 10 days and not have to get any licenses, permission. nothing.
Your Honor,
So,
you've made the comment already about argument. I was going to do that earlier, and there hasn't been any actual testimony so far. This needs to be factual. The argument can be made from there or in
I'm just laying
writing.
a foundation for my state of mind.
All right. Well, I don't need a foundation for your state of mind. I understand you've heard my order, the words that were in the order, and I heard that you believe that the ordinance states you can rent for 10 nights or less without needing to get the permit, okay?
Right. So I went ahead and rented my property for 10 days for this past summer, 2025.
All right. So I'm hearing right now, I just have to make sure, you are admitting and stating on the record you've rented it for 10 days.
Correct.
All right.
And with, I'm looking at Exhibit 4, what I did is I said that 2 days of the 7 were paid and the other 5 were complimentary to kind of save 5 of the 10 days. So of this, for Mr. Bennett, I'm counting 2 of the 10 for that purpose.
Okay. Got it.
And that's what shown here on the rental agreement.
All right, so then go forward and continue to go down, tell me the days that you rented, to whom you rented it to, and we'll go from there.
I don't remember. I just specifically remember it was 10 days when you include the 2 days, the Memorial Day weekend, the Labor Day weekend. So that would be 2, and Mr. Bennett is 2, that would be 6. And I think there was another rental in there. I just remember that I wanted to keep the limit at 10.
All right, and so with the Memorial Day rental, with the Labor Day rental, with Mr. Bennett, it was, you rented it per your contract or how you had written the contract, 2 days for each. So a
Right.
total of 6. So where's the other 4?
Well, we got the Labor Day, right? Did we
I already
include
did
that?
2, 2, 2. So that's 6. So there's another 4.
Let's see, that would,
Because we have the May, we have the September, and we have the July with Mr. Bennett. So,
I guess what I'm saying, I kept within the 10 days. I don't remember exactly the 10 days specifically, but that was my goal, or my intention is just to stay within that 10-day limit.
okay, all right. What else do you want me to know?
I think that's it. That's pretty basic. That's, I admit to the renting. My understanding though, it's 10 days or less. That's what the county ordinance is. That's what the state law says in the right to rental.
Okay, and so nothing else you want me to know? And what about the money issue? You wanted to argue about the money issue. Tell me about that, or not argue, tell me about that in your words, because you were saying you were trying to have other witnesses tell me about money.
Well, it's just that he's trying to argue if he tries to argue a sanction that I was paid $5,000, that all didn't come to me. There were tons of VRBO fees and taxes and things like that.
Okay,
That's just the point I was making there.
understood. So you didn't receive all the fees. Some of the fees went to VRBO and some went to taxes.
Right.
Excellent. Okay. Anything else?
That's it.
Mr. Anderson?
Mr. Olson, to be clear then, you did not receive permission from Burnett County to rent your property in Burnett County, true?
I never asked them for permission.
Fair enough. Then you never received a license from the state to rent your property in Burnett County, true?
No, because my understanding is I didn't need a license for 10 days or less.
Okay, so no, you didn't.
No.
No further questions.
All right, you may be seated.
Okay.
Okay, now, argument.
Your Honor, so a couple of things. I don't think first of all, Mr. Alsiums has admitted to renting the property in Burnett County, in my opinion, in violation of the court order. We heard testimony from Debbie Tate that they brought multiple trailers, multiple ATVs, multiple vehicles. They had 12 people there one night, 10 people there another night. We heard testimony from Mr. Bennett that there were double-digit people on the property. There were multiple vehicles on the property again. This is sort of that nuisance. It's not sort of. This is part of the nuisance that has been part of the problem. There's been more than that, but that's been part of the problem and part of the issue of how many people are renting the property and staying there when this is not a commercial property. We've also heard testimony from Ms. Tate that she was there for 2 nights, 3 days. We heard testimony actually from Mr. Alsiums I'm sorry, not from Mr. Alsiums. We have exhibit 1 that shows that the group that was there in August 28th through September 1st was there for 4 nights. It says $995 times 4 nights. We have testimony from Mr. Bennett that they were there for 7 nights and 8 days, and they booked their vacation. I think he said 7 or 8 months prior to the vacation actually occurring. And then we have a rental agreement sent to Mr. Bennett at 5 p.m. the day before they are supposed to go to the property owned by Mr. Alsiums for their 8-day family vacation. And obviously they signed it and moved on. And then they looked at it later and saw that there was this clause in there about complimentary days. That is a sneaky way of trying to get under the 10 days, which I don't think applies anyway in this case. But even if it does, Your Honor, the point of it is they were at the property for 7 nights and 8 days. The people from August 28th to September 1st were there for 5 days and 4 nights. We're already at 11 nights between those two. And then we have Debbie Tate, who was there for 2 nights and 3 days. Now we're at 13 nights and more days. And then not even to mention the other 2 groups that were renting, one from August 8th through August 15th, which again is another 8 days and 7 nights. And the last group being June 6th through the 8th. That was the one with the ambulance There's less information about that, frankly, but there was extenuating circumstances there. But point being, Your Honor, there were renters there in far greater numbers than 10 nights. And again, I don't think that applies, but since Mr. Alsium's arguing it, I feel like I should respond to that because we are at 13 nights just for the 3 groups that have been proven here today in court without even considering the additional 2 groups. So any way you slice it, Your Honor, whether it's by what I consider the letter of the law in terms of he's not supposed to rent, period, without a license or permission from Burnett County. But even if we do have if that is the law, which I don't believe it is, he's still in violation of it. So frankly, a lot of the argument from Mr. Alsium's doesn't matter because he's in violation either way. If you want me to address sanctions, I can do that. I can do that later. I would ask for attorney's fees, Your Honor. And I didn't know how long today was going to go, so I'd ask for a little bit of time to submit that. So I can't do that today because I didn't know how long it was going to be.
All right. So yes, argue sanctions, and then he will have the opportunity to refute all that you've argued.
All right. Your Honor, I think sanctions are appropriate here. He's already been found in contempt of court for this very same action in the past. The court sanctioned him then. I think the court should sanction similarly. I think Mr. Alsium is right. He predicted that well because I think I did it last time. But the fees that were paid, I can do the math, but there's the $3,980 that was paid for the 4 nights in September. And then Mr. Alsium talks about service fees and tax. Well, that's fine, but the cleaning fee went to Mr. Alsium's and so did the $3,980 for that one. We can look at the one for Ms. Tate. She paid $1,990. Then she has host fees, which again would be to Mr. Alsium's service fee and tax. We can take that off. Those numbers, again, are fairly clear. So that's $2,380. Your Honor, we also have Mr. Bennett, and his was $5,665, which was the per night of $809.29 times 7 nights. That's on Exhibit 3. There's a cleaning fee that went to Mr. Alsium's service fee and tax. We can take those off and that's fine. But I think that the profits and the money that was received by Mr. Alsium's are ill-gotten gains in a case like this, and those should be forfeited by him as a sanction. And then I defer to the court on additional sanctions. In the prior contempt order, Your Honor, there were purge conditions. Obviously, those purge conditions did not happen. And now we're here on round 2. And I don't normally expect to see round 2s on things like this, but here we are. And that's why I'm asking for sanctions as they are and attorney's fees. But again, I'd like give me a week or 2 to get that to the court.
Right. And so your argument is you were arguing for sanctions. Your argument is, if I'm hearing correctly, that you are making an argument and a statement that purge conditions were ordered by the court to Mr. Alsium's. And pursuant to the court's order, Mr. Alsium's did not comply with the purge conditions. So that's one of the arguments. The second argument is you're arguing for attorney's fees to have to come to court for today and all of the related expenses to today's hearing. Plus, you are arguing to the court that a sanction for Mr. Alsium's should be forfeiting all of the funds that he did receive and profit from the rentals that you had proof of.
That is a good summary.
Excellent. Thank you. Mr. Alsium's.
Again, Your Honor, my understanding was 10 days. That was my intention. I don't think Mr. Anderson's math quite adds up, but they've only presented Mr. Bennett and Ms. Tate. That's 2 days and 2 days. That's 4. Again, it was my intention to stay under the 10-day limit. And I think even you made a reference yourself at the beginning of the hearing that it has to be within the ordinance. The ordinance is 10 days.
I said that was your argument.
Right, but that's what my understanding was, that that's any person in the county would get 10 days. I don't see why I would be any different than that.
Okay. Any response to the other arguments that Mr. Anderson made, especially as it relates to any types of sanctions?
Again, I believe I complied with the order, so I don't think any sanctions are appropriate. It was my intention to comply with the order until all of this is finally adjudicated. So.
All right. right, so Mr. Olseams, I do have a question for you as it relates to this matter. And it's a hypothetical. I just want to have an understanding of where you're coming from and what your thought process is as it relates to not only the Burnett County ordinance in the state as it relates to the 10-night limit, but also as it relates to you and your givings, I guess, your generosity, I guess, as it relates to the renters. That's the argument I'm hearing from you.
Wait, you mean the free days, you mean?
Yes. And what was your purpose of the free days to individuals, other than staying within that 10-night limit?
That's the only reason.
That's the only reason?
Yeah.
No, again, grandiose generosity, those types of things. It's just so you can stay within the limit?
Well, sometimes somebody will ask for an extra day, and because I can't rent it continuously, I would have, say somebody was there for a couple of days, there's nobody there after that. Somebody might say, can I stay a few extra days because I had a wedding, or I'll let them do that.
Free of charge?
Free of charge, yeah.
Didn't your last renter from our last hearing, our last contempt order, she wanted to stay there for additional days? There was something, she was staying there for a wedding, but then she had to pay extra money?
No, exact opposite. She wanted to stay longer and I didn't charge her for it.
You can refresh my recollection with the transcript, and I could do that. I just want to have an understanding. So I also want to have an understanding. I just want to wrap my head around this. So you wanted to stay within the 10-night limit, correct?
Right.
And you have testified to court and you admit that you stayed, you rented 10 nights, 10 days only, correct?
10 days or less, yes.
10 days or less. So you've rented the limit of 10.
Right.
All right. 10 days, 10 nights, 10 days.
10 nights is kind of like because again, somebody, if they just stayed a night, they would come the first day, stay the night, and leave the next day. That's technically 2 days, but it's one physical day. That's why it's by the night.
Okay. And so I can have an understanding that you did state and you admitted that you rented for Memorial Day weekend 2 nights, for Labor Day 2 nights, and for Mr. Bennett, he stayed 7 nights, but you only charged him for 2.
Right.
And with regards to the amount, I think it was like 6,000 something, almost $6,800 and $6,840 if I'm going off my recollection, but I don't have it, can't find it exactly in front of me at this time. Yes, it was 6,000. So $6,980.48. All right. So Mr. Bennett, he stayed 7 nights, but you only charged him for 2 nights.
Right.
And so the 2 nights that you charged him for cost $6,980.48.
Right.
Okay. But then you're like, yeah, 2 nights, but I'm going to give you 5 for free.
Right.
And then you had, so that's 6. And then, so there were other rentals that were discussed earlier. We don't have any exhibits or proof or evidence from Mr. Anderson or Mr. Brimacone, but you are admitting then you did rent to other individuals for at least 4 days.
I just recollect that I wanted to stay within the 10 days. I don't remember exactly how that all played out. I just wanted to stay under the 10 days.
All right. So in those rentals, and you don't recall, and I don't need specific details. I just want to have an idea. In those rentals to individuals, was it more than 1?
I don't recall. I think it was maybe 1 or so. I don't remember.
It could have been 1. It could have been 1, could have been 2, or are you pretty sure it was 1?
I don't recall exactly. I just know it was 10 days, or I wanted to stay under the 10 days.
Okay,
the 10
and I
nights.
get that, and I understand your argument.
But I don't recall exactly which.
Recall exactly if it was 1 or 2. Let's say it was 1. Do you remember if that person, that individual, were you nice to them too, and did you give them some free days?
No, it was only for the 7-day stays.
Okay. All right. So they didn't stay 7 days?
No.
Or was it going to be a 7-day with that person and you only had them pay for 4, but then you gave them additional 3?
I don't recall. I just recall that it was like a 2-day type of a thing.
What do you mean it was a 2-day type of a thing?
Well, I only do the complimentary days on someone that wants to stay 7 days. Anything that's less than that. So I'm kind of adding everything up. Well, this is 2, and 2 here, as
Okay.
long as I stay under the 10.
Do you remember in this past year, since my order and your understanding of the order, other than Mr. Bennett, did you give anyone some free days?
I don't recall.
you've been in front of this court before and you are meticulous at keeping records, is that correct?
Not really. Again, I just generally know that I have to stay under the 10.
Okay, and I understand that, but in our other cases, it's my understanding and my interpretation of how these cases went. Would you say that you did have all of the documentation in the other hearings?
I actually didn't. I think Mr. Anderson is one that had all the documentation.
Not in the contempt hearing. Let's go to the other hearings.
Yeah, even the other hearings, it was Mr. Anderson that had all the documents.
Oh, so Mr. Anderson is better at keeping your records than you are?
For the most part, yeah. Because he's trying to prove rentals.
Oh, good
So-
job for keeping his business records, Mr. Anderson. Okay. And so then how do you pay your taxes, Mr. Olsiums? Because
Well,
you need to keep business records. You need to know how much money is coming in. And you need to be able to report that to the state as well as the state of Wisconsin, as well as to the federal government.
Well, there's a federal law called the Augusta Law, which came from homeowners that were renting their properties for the Masters.
Okay.
And they were renting them just for the tournament. And out of that came a federal law that says if you rent your property for 14 days or less, you don't have to declare the income.
Okay, all right.
It's called the Augusta Law.
And so does that include all of your rentals or just your rentals in Wisconsin and then separately from?
Per property. Yeah.
Okay,
So it's just kind of well, I know I have to stay under the 10. I don't have to do meticulous record keeping because it's under the 14 for taxes. So I just know it's 10 days or less. So it's kind of an informal, lackadaisical. I think the reasoning there is the difference between a serious business and just kind of informally renting your property, which is what the people did at the Masters. They're just getting some side income.
all right. Well, then I have to talk to my accountant.
It's actually a great law. And when you think about it, it's kind of you don't get to write everything off though. You get to not declare the income, but then you don't get the write-offs.
Okay,
So it's kind of it's kind of the line between a serious renting business and, it's your property that you live in that you're just occasionally renting.
and what year did that happen?
Probably 30 years ago.
30. Why?
It's been around a long time.
I was in the rental business, not before I was a judge. And I did short-term rentals and things like that. My accountant never told me that. I'm going to go back and get my money back.
Well, did you do more than 14 days
No, I did not. I stayed within the 10-night limit.
here in Burnett County?
Yep.
Yeah, well, it's a nice law, actually. Again, it's called the Augusta Law, 14-day.
I'm going to look at that, and I had other property too in other places, but my accountant is going to hear from me for sure.
So just in general, for the last couple of years, until this whole thing is adjudicated, I've moved it from a serious rental business to lackadaisical, 10 days or less.
You're there renting some, but giving 3 days.
Right. Just to kind of like say somebody wants to stay 7 days and I'll try to stay within that 10 day. Well, here's some free days kind of thing, which I did for Mr. Bennett.
All right. Okay. All right. 3 days. Okay. Now, Mr. Olsiums, I'm going to turn to you for your motion. I need to pull that up though. Your motion to stay, and Mr. Anderson, you had that too, correct? You understood you filed one?
A
long time ago.
It was, I didn't recall it, but yes, I do now.
So I'm just going to give him the opportunity. It wasn't specifically noticed or request to have a hearing, but I'm going to give him the opportunity right now. We're all here, and just so he can argue that. And it was filed on November 3rd, 2025. I'm pulling that up right now. Okay, Mr. Olsiums.
Well, just as we know, this is, I've asked the Court of Appeals to adjudicate. There are numerous from A to Z in this case. Whether or not this could even be a nuisance to there's probably, I've identified 6 or 7 major legal concepts that I'm going to ask the Court of Appeals to address.
6 or 7?
I mean, when you think about it, from the nuisance, to the injunction itself, to all my claims being dismissed. There's really a whole litany of stuff. And I think just to make it, fair and kind of make sense, I actually think that this is going to set precedents at the state level for, can something like this even be a nuisance? Right. And I think that, it needs to be decided at a state level, that there's a lot of short-term, renters, property owners in Wisconsin that want to.
You can understand that it could make case law. It can't make statutory law. That's something that the legislature would have to do, and the legislature would have to change.
Right.
All the Court of Appeals would be doing would be looking at my decision, the facts of the case, and seeing that I stayed within my parameters and I didn't, do anything gross.
But I think the issue that it comes down to is nuisance. It's really the garbage can law of really not just Wisconsin, but any state. I think Mr. Anderson and the plaintiffs were desperate if you understand this is like an island. It's not like a city block.
Find it. It's not an island. It's
peninsula. Peninsula. But the point I'm trying to make is that, they've been out there for 30 years. I've been out there for 30 years. Everybody looks at it like their backyard. So when strangers come up the road and you come onto the peninsula, it's kind of like somebody coming in your backyard. You're like, oh, I don't like that. But, we have a right to rent our property, and, getting into whether it's 10 days or does the rental. Another thing, I think it further clarifies the right to rent law that Scott Walker passed in 2017. I think the purpose of that law to begin with was to, stop. It was to enforce the right of a property owner that they have a short-term rental right. So I think when you understand this island, it's not like a regular, certainly not a city lot. It's like where you have a block and there's house. And it's not even, I don't even think it's a regular lake lot, because if you think of a regular lake like Devil's Lake, a circular lake just with property next to it, this is a peninsula. So there's only 4 owners out there. So they all look at it like, hey, this is like our backyard. So when strangers come up the road, they're kind of like, how would you feel about somebody coming in your backyard? So I think they went to Mr. Anderson and, hey, we, find some legal theory to stop this. And, nuisance is kind of like the garbage can. And again, I my research on nuisance law, again, you can't just say, like, for example, I don't like somebody mowing their lawn. I don't like the noise and it bothers me, and I'm going to say it's a nuisance that somebody is mowing their lawn. Well, it can't be a nuisance because they have a legal right to do that. It's like, if I don't like somebody driving down the road, I don't like the sound of their car. It's I feel that's a nuisance. Well, it's not, because we all have a right to use the road. So similarly here, because it's a peninsula, because everybody's been there 30 years, they kind of look at it like their backyard. They try to find something. And, garbage, that's why they call it the garbage can of law, nuisance. If there's not a specific law, or there's maybe other exact law going against us, let's claim it's a nuisance. So if you recall Mr. Brimacombe's testimony, he didn't really say he had any, there were no police called, there were no loud parties. They tried to say that the septic system smelly, and if you recall the damages hearing, I showed that, Mr. Brimacombe claimed that there was like 16 cars. It wasn't even possible to have 16 cars there. So they just, are using this nuisance law to try to claim, which is again the basis for this injunction, for this renting, which I think is a, major linchpin in this entire case, right? If it's not a nuisance to rent your property, then everything else falls apart. So that's why I think the make sense thing to do is, let's let the Court of Appeals kind of hammer out these, because again, this is, I feel it's probably going to be a set precedent for the state.
How so?
Again, if I have a legal right to rent my property, how can that even possibly be a nuisance? If it's like I have a legal right to use the road in front of me, I have a noisy car, is it a nuisance to run my car up and down the road?
You're getting really, really far off of the facts or where we are.
Well, just the concept is nuisance. Is it a nuisance to rent your property? I mean, they tried to show the smelly septic because they tried to show that they try to get away from the actual point of renting your property can't be a nuisance. They were trying to say, well, it's a smelly septic because they have 14 people renting. And that's why the smelly septic is because there's 14 people renting the property. And
Mr. Alsiams, I'm going to stop you right there, because if you were to have properly followed the law and you were to have gotten your tourism license and the Burnett County license for the short-term rental, your septic would need to be looked at, and you would be told the exact amount of people you could have in that property based upon that square footage and the septic that was installed, if you would have done what you were required and legally required to do.
But if I can make a comment on that, I'm actually a construction person. I've actually installed septic systems.
I know you
and the point
said that in the last hearing, and I heard that.
And the point is, the usage and flow on that, it's continuous flow. So even if, for example, if I have a party at my house and there's 20 people there for a weekend, that's not going to overrun the septic system. You have to have week after week of 30 people. That's just not happening here.
Okay.
And so they're trying to argue smelly septic because there's more than, again, just the desperation to try to, climb in
one of the nuisances.
Right. But again, that was refuted because there was no inspection done. There was no professional that came out and said, yeah, it's malfunctioning because there were 14 people here that weekend. I mean, it takes week after week, month after month of over.
Right.
So again, so I think why a stay would be appropriate is that, it's not, just the nuisance part, which again, if that goes, everything pretty much falls apart. If, my claims, again, there was general, disputed material fact. They basically got up and just with an affidavit said, I'm claiming this. And I got my affidavit in the same day of the hearing when we had that. So we have a disputed fact there, and all my claims were dismissed because.
Okay.
So again, there's a lot of things going on. I think
what
that.
Is your legal basis? Do you have any case law? Do you have statutory law? Do you have something for me to hear or to understand? But what is your legal basis for requesting a stay?
Legal basis is that.
That means case law, that means statutory law. What is that basis?
Well, I think, statutory, as I mentioned, nuisance. Can this be a nuisance? This is a primary fundamental right of any property owner in Wisconsin. I've suffered, lost rental income for the last couple of years because of this. This is a major harm to me by. Right.
Yeah. Okay,
so until I just think it makes sense that, structurally in case with the law that, this isn't a garden variety claim damages. There's a lot of legal merits here that I think need to be determined statewide. And it makes sense just to put everything on hold until the appeals court rules.
Okay. I understand that now. Now, with regards to the court's October 4th, 2024 order, I have your understanding of that order. You filed a motion to stay. The court did not hear your motion to stay, and I could have ruled on it at that very moment. I did not.
I'm sorry, 2025, you mean? Or
25, yeah. October 4th, 2025. Sorry. And in that order.
It's actually 24.
It is 24. It is 24. See, I was correct. October 4th, 2024, right?
There's another one that looks like it's September 5th of 2025. That was, I believe, the contempt part, but the original one is the October of 24.
Yes. Okay. So thank you. This has been a long process. Thank you. Because the important thing here and what the court has to do is take it by stages, because the court first ordered October 4th, 2024. And I read to you what the order was from the court that you must comply with. And I'll state again, the court hereby issues permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required until such a time that the above depicted nuisances can be abated. That's the October 4th, 2024. Then the court had another order that the court entered on August 28th, 2025. From August 28th, 2025, the court had certain orders and found that you had certain compensatory and punitive damages for nuisance, for civil trespass, and for property. The court also found you in contempt of the court's October 4th, 2024, and had certain sanctions that were applicable at that date and time, and gave you purge you understand what purge is? Gave you the ability to purge that and to, as long as you complied with certain things, the jail, it says the things may be purged following full compliance of the October 4th, 2024 order, or 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. All right, so that was the court's August 28th of 2025 decision. And so with regards to the August decision, Mr. Olsiums, did you comply with that order?
I guess I don't,
Did you comply with that order with paying the court fine of $2,500 for each violation?
I didn't pay the fine, no.
You didn't pay the fine?
No.
Because I think if I calculate it correctly, I think the fine would have been due and owing October 26, 2025. So by October 26, 2025, you did not pay that court ordered sanction of the $2,500 for each of the violations?
I guess I didn't see that in the order.
But you did receive a copy of the order, correct?
Yes,
And you are an e-filer too, correct?
yes,
And so you did receive that order from the court, which does have that sanction, as well as it says court fine $2,500 for each violation, totaling $5,000, a 45-day jail sentence for each violation to be served consecutively for 90 days of jail. And it says that the jail sentence may be purged. And that means you won't have to sit the jail if you do these following things: full compliance with the October 4, 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. I get your argument as to you believe that you're in full compliance. You believe you complied with my order, but so you didn't pay those fines and fees by October 7th within 60 days from the court's order.
I don't think I even have that money to pay.
But you got the order and you understood the court's order as well as the purge, correct?
Yes,
Okay, now, with regards to that, I've heard your argument for stay. I've heard those things. Mr. Anderson.
Your Honor, there's a lot of argument about the facts of what happened and sort of a rehashing of that. And I don't think that's anywhere near the standard for a stay. My understanding, and I don't have any case law or statutory citations to point the court to as I sit here right now. If I go back to my office, I can find some, but part of it, I believe, in arguing these before is
Sorry, I'm sorry to interrupt. I wanted to then say that his stay, my decisions were October 4th, 2024.
Yeah.
August 8th, 2025. And then the court received a motion to stay on November 3rd, 2025. I just wanted to state those dates on the record.
And just to be clear, it's August. It looks like it was date signed August 29th.
Oh, 29th. Yes.
Yeah, just making sure.
Oh, sorry. Let me repeat that. The first order, October 4th, 2024.
Yeah.
The second order, August 29th, 2025. Mr. Olsium's motion for the court to stay all orders pending appeal filed November 3rd, 2025. Would you agree with that, Mr. Olsiums?
yeah, apparently, yeah.
Yeah, okay. Mr. Anderson. Sorry to the dates.
No, that's okay. I'm trying to think about the timeline for that too, Your Honor. But I think part of that is a likelihood of success on appeal. And I think that's a huge factor that should not be overlooked. The argument, Your Honor, Your Honor touched on something I was thinking when Mr. Olsiums was making his argument, is that the Burnett County ordinance, with the 10 days and the requirement for the license at DATCP and the permission from Burnett County back in 21, 22, 23, 2024, all the way back, was never complied with. That's clear in the record from the prior hearings. It's clear again today when Mr. Olsiums testified that he didn't go get permission for Burnett County, did not get the license from DATCP. That in and of itself had he done that, would have allowed what Your Honor already said about the county and the state putting some requirements on there, but it also would have allowed, I think, based on the Burnett County ordinance, it would have allowed the neighbors to have input as to what their concerns might have been, which may or may not have, but at least they would have had the input. It may or may not have had an effect on what those requirements might have been from the county as to what Mr. Olsiums was required to do in order to allow him to rent the property. This is a residential area. This is not a commercial area, but Mr. Olsiums treated it as a commercial area. And so likelihood of success on the merits, Your Honor, being a factor, as I understand it, that's just not there. The arguments are akin to what he's making today on the contempt piece, Your Honor. Exhibit 1 says 4 nights. Mr. Alsium's was the one that exhibit went through and through him. Exhibit 3, it says 7 nights. And if Mr. Alsium's, it's a strained argument at best that he rented his property for $7,000 to Mr. Bennett for 2 nights and then just gave him the other 5 nights for free. It doesn't pass the smell test whatsoever. And then exhibit 6, Your Honor, shows another 2 nights. So again, just the exhibits that have been presented to the court for those 3 stays in 2025 show 13 nights. His argument about the nuisance is almost as strained as the argument about his rental activity in the summer of 2025. He has, in my opinion, very little chance of success at the Court of Appeals on this case. A lot of it was, it was based on this court's review of the record, late submissions by Mr. Alsium's, no issues of material fact. And ultimately, as Mr. Alsium's has continued to prove, he doesn't care what the law is or what the court orders. He just does whatever he wants. And so with all of that as a backdrop, Your Honor, the stay should not be imposed. Who knows what will happen to the property or any assets that Mr. Alsium's might have if a stay is imposed, and he's allowed to be free to dispose or dissipate his assets, whatever the case may be. I think the lien needs to stay on the property. I think if my clients decide that they want to file a foreign judgment over Minnesota where Mr. Alsium's lives, they should be free to do that to secure their rights in the assets that would be able to pay the judgment. Additionally, in the event that my clients do a levy of execution or something like that, garnishment, et cetera, and the Court of Appeals comes back and says no, or somehow for some reason grants Mr. Alsium's appeal in some fashion, well, then my clients would be on the hook to repay that. It's no different than the situation we're in right now. And so I don't think that there's any reason to stay the court's judgment, given the behavior of Mr. Alsium's, given his propensity to ignore the law and do whatever he wants. I think for the protection of my clients, Your Honor, the stay should not be imposed.
All right, thank you. You get a brief rebuttal.
Just that I've acknowledged the 10-day rule until this is all adjudicated, and I've adhered to that, and I have not done what I wanted, restricted my rental until this is all adjudicated.
Okay, and there was another issue that had come up, and I just need to make sure that everything's taken care of, because you filed an appeal and you needed a transcript, and there was some kind of conflict that was going on with regards to payment of that transcript. Was that transcript paid for?
Yes, that's all been taken care of.
Okay, how was it paid for?
Through Venmo.
Through Venmo?
Yeah.
Okay, and so when was it paid through Venmo? She can't testify, so do you have an idea? Because
A month
my
ago.
order went out on January 6th, 2026.
It was before your order, before the 15th. I think it was the 10th, maybe. Or the
That's not
6th.
what I recall, because otherwise I wouldn't have done the order
I know I did.
after that,
I did the payment the day of the order.
the day of the order.
Yeah.
Okay, so you paid for the transcript by Venmo the day after you received my order.
No, the day of your order. I think it was the day of your order, the same day.
Same day of my order. So my
Yeah.
order went out January 6th right away in the morning, and then you paid for the transcript by Venmo later that day?
I think your order went out in the afternoon, and I had paid, I think, just before your order,
I mean,
actually.
that's easy to check, Mr. Elsiams.
I'm sure.
I can definitely get that and get it all verified. But that's not my understanding. It wasn't paid for. Otherwise, I would not have done an order. And so my order did say pay for the transcript. This is all bold and capital. Payment for the transcripts be made on or before January 15th, 2026, and yada, yada, yada. Then again, and all bold and capital, payment shall be made by cash, underlined, or money order, underlined, payable directly to the court reporter. And you paid by Venmo?
Well, we had been discussing payment for a month, and she said that she accepted Venmo, but would be a fine payment. So that the day of your order, that's when I paid via Venmo, because I established a Venmo account, and I paid her via Venmo the same day of your order.
All right. So you paid the same day. All right. Of my
Yeah.
order. So you didn't do what you wanted to do and paid by Venmo, even though the court ordered you specifically to pay cash or money order because of the difficulty that arose between payment, correct? Correct?
Her and
Yes or
I-
no? Yes or no?
No, we were speaking for a couple months and she said that Venmo was
I'm
acceptable
not gonna
payment.
have her in the middle of it. I just know my order went out on January 6th. You paid January 6th by Venmo.
Right, yes.
Right, okay, all right. So with regards to the motion to stay, there are things that the court has to follow. There are, and State v. Guddenschwager, 191, Wisconsin 2nd, and it's GUDENSCHWAGER, 1995. It says the court must look at 4 specific things. 1, the likelihood of success on the merit, irreparable harm to the other parties, and the public interest. All right, and I've heard the arguments of the parties, and I understand, Mr. Olsiams, you believe that this is going to create new law and precedent, and the Court of Appeals will make everything right and will define nuisance and will overturn this court's decision and the orders that I have, not just 1, but 2. I have two orders in this case, 2 separate orders in this case. Court here, I don't find that you have shown that or demonstrated a strong probability on appeal that it will be successful. The court thoroughly went over what nuisance was. The court thoroughly went over the violations that were occurring while you were renting your property out to other people. Very, very clearly in my first decision, because my first decision, it's 26 pages long. Granted, it's not all 26 pages. It's 15 pages of the court analyzing the law, interpreting the law, and analyzing the facts of the case, and then putting it on a decision in order. The other pages from page 16 to 26, those 10 pages, they were here to help you out. A guide to renting out your property for overnight stays. Protect yourself by knowing Wisconsin's law for short-term rentals. I gave you that pamphlet, so it would explain the law, explain what you need to do. So that was there. The second thing was the Department of Agriculture, Trade and Consumer Protection, the tourist rooming houses, and what you must do to follow that law for the DATCP. Then the court also provided you with the permit application for the tourist rooming house. So you could have that, along with another brochure, the Wisconsin Short-Term Rentals Law. And it has little arrows and things and little boxes, and it makes it really easy to follow to make sure that what you need to do to comply with that law. The court then also provided the short-term rental license application for Burnett County, clearly gave it to you, showed what you needed to do, had it right there. And I also provided the Burnett County licensing requirements right there, so you could have them right there with the additional provisions. And then I, beyond that, provided Burnett County Ordinance Section 30-455 short-term rental, which clearly goes over what a short-term rental is. And I went beyond that because there's issues and arguments with parking. I put in Burnett County Ordinance Section 30-480 parking as it relates to off-street parking. And here it would be with short-term rentals. Very clearly laid it out because you were very clearly violating the law. That was well proven, directly proven. I don't think it could have been proven any more clear to the court that you were violating Wisconsin state law and Burnett County ordinance. And the court did state that. And then the court did, that's why I entered the injunction with those requirements that you, again, I will read it to you, that what my order says, word for word, my order says, as such, the court hereby issues a permanent injunction until such time that Mr. and Mrs. Olsiams complies with and receives the state DATCP rental license and the Burnett County rental permit and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. So there's 2 things here. I hear your argument about nuisances. You want the Court of Appeal to look and see, wow, Judge Mogan doesn't understand what nuisance law is, and that's fine. But then there's that other first part that the court clearly says, permanent injunction, meaning not 1, not 2, not 3, 0. No free days, no none days, no, I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. But I'm only renting you for 1 night. Clearly says permanent injunction until such time that you and Mrs. Olsiums, that you comply with and receive the state DATCP rental license. That you do that, and the Burnett County rental permit, and you continue to do so annually. So you stay compliant. The order does not give you authority in any way, shape, or form, to rent at all, even with the Burnett County ordinance of, having, or the state, which says 10 nights or less, or 10 days or less. Nothing about that. And the court's order clearly defined all of that. I had all of that information in my order. So if I was going to give you authority to say, all right, you can rent it for 10 days or less. I mean, really, you can rent it for 20 days as long as you give them 10 for free. That's totally fine, but charge them for the 20, but you only rent them for 10. I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those 2 things. All right. Until you do those 2 things. You did not do any of those things. Instead, you rented it. You were found in contempt. You had far more days for the rental at the last contempt hearing. So the court found you in contempt. And this case, you're like, I'm going to outwit the legislature. I'm going to outwit the Burnett County Board. I'm going to outwit Judge Mogan and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? I know how to analyze the law. You were trying to be sneaky and deceptive, and you were trying to get away with something that is clearly not legal or correct. You rented over the 10 days again, whether it's 11 days, whether it's 13 days, whether it's 14 days, you admit on the stand and at the table it was 10 days. I rented 10 days, exactly what I said I could do in the ordinance. I did not do above, but I did give them 5 free days. Can't remember anything else, but I gave them 5 free days. So that's 15 days. 15 days you admit to. 15 days you admit to. I don't even have to go with any evidence or anything that's been filed or served by or received by the court from Mr. Anderson. You admit to 15 days. 10 you rented for money and 5 you gave for free. Even if I were, Mr. Olsiums, to take you and believe you, that is your understanding. And even if the court were to go, I don't think I wrote my order as clearly as I should, which I did though. Even if I took that and listened to your argument, you violated the ordinance. Free days count, Mr. Olsium. Free days are not free days, especially when you're charging $6,980.48 for 2 days. What fool's going to pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart, probably smarter than I am. They do this all the time. They're not going to fall for your shenanigans. They're not going to. You're nodding your head up and down. I don't know what that means if you're saying yes or not, but that's where we are. You violated the order again. So I do find you in contempt for these violations. As to the sanctions and whether or not the court orders attorney's fees, etc., I am going to stay on the sanctions part of the decision because I don't have that information in front of me. And with the last contempt, I did deny attorney's fees for particular reasons, and I can't just go off of this is how many hours it is. There has to be the other arguments per the statute and the Supreme Court rule. But I do find you in contempt. Further, beyond that, you didn't follow my August 29th, 2025 order. Very, 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 very clear. $2,500 for each, capitalized each, violation, parentheses 2, totaling $5,000. plus a 45-day jail sentence for each, capitalize each, violation to be served consecutively. Serve 1, serve 2, for 90 days jail in parentheses. The court or the jail sentence may be purged. You may get out of that completely. I don't have to do it. That's good. I don't want to go to jail. On the following conditions: full compliance with the October 4th, 2024 court injunctive order. One way that you can purge it, plus the second way, full payment of the court sanctions, fines, and fees within 60 days. Court calculated it. I did it twice. I did it 3 times actually. The deadline was October 27th, 2025. You had until October 27th, 2025, Monday, to pay that, to purge your jail. You didn't do that. Moreover, even still, your motion that you filed to stay all orders pending appeal was filed on November 3rd, 2025, beyond the deadline that I gave you to purge. Beyond that, it's late. It doesn't count. You may want me to stay the other decisions, that maybe the other parts of it, I guess. I don't even know, because I'm going to tell you, your motion, your petition here, it's hard to understand. Doesn't even make sense. And you're just spewing things that you think and you interpret as the law, or actually what you want the law to be and how you want it to be. So you can follow it and you can do what you want. So the motion to stay is denied. I don't find that you've met any of the factors that you need to meet. I don't think there's a high likelihood of success on the merits. I just went all over that. I don't think you're going to be irreparably harmed by if the court doesn't stay it, because it sounds like you're going to do what you want to do anyway, and you're going to try and do it and just hope you don't get caught. Harm to the other parties, harm to all of the other plaintiffs and all the other people here is higher than yours, because you continue to do these things. Not only, we're not just talking about the sewer. That went away. That was the only time I heard about it. Then I heard about the damage to the trees. I heard about the urinating in front of their camera. I heard about all of those other things in which the court found you nuisances, you violated, you did things that interfere with their ability to enjoy their property. The public interest here, I have to weigh the public interest. And here the best interest of the public is not to stay. It's to continue to have these specific parameters in place that you must follow, because it's been shown that you do not follow. You don't follow the law. You don't follow what the legislature says. You don't follow what the law enforcement says. You don't follow what the court says. You don't follow what anyone says but you. So I'm denying your motion to stay, and I'm finding you in contempt of the court's contempt order. I'm imposing those sanctions. You failed to pay $5,000 by October 27th, 2025. That means that the jail sentence stays 90 days in custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6th, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiums.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
How would I make?
Go up to jail.
Thank you for watching. Before we wrap up, we're going to spend a few minutes breaking down the laws and court rules that matter in this case, in plain language, so viewers who aren't familiar with the legal system can understand what actually went wrong here. This case is not really about short-term rentals or websites like VRBO. At its core, this is about court orders, injunctions, and contempt of court, and why ignoring them is one of the fastest ways to end up in custody. When a judge issues an injunction, that is not a suggestion. An injunction is a direct court order telling someone to stop doing something or to do specific things until certain conditions are met. In this case, the court issued a permanent injunction tied to two requirements. First, obtaining a state tourist rooming house license from the Wisconsin Department of Agriculture, Trade and Consumer Protection, and second, obtaining a Burnett County rental permit under the county ordinance. Legally speaking, that means no license and no permit equals no renting, period. There is no loophole, no workaround, and no close enough. This is important. Once a court issues an injunction, the underlying debate about whether you agree with the rule is over. At that point, the only legal options are to comply with the order or appeal the order through the proper courts. What you cannot do is reinterpret the order yourself and decide which parts you think apply to you. That's where contempt of court comes in. Contempt is not about punishing someone for having a bad opinion. It's about enforcing the authority of the court. If a judge finds that someone knew about a court order, had the ability to follow it, and chose not to, the court can impose sanctions. Those sanctions can include fines, forfeiture of money earned from the violation, and jail time. You also heard the judge talk about purge conditions. A purge condition is basically the court saying, here's what you must do to fix this and avoid jail. It's a final chance to come into compliance. But that chance comes with a deadline. If the person does not meet those conditions by the date in the order, the court is allowed to enforce the sentence. At that point, paying later or offering excuses does not undo the violation. Courts rely on deadlines because without them, court orders would be meaningless. Another key point here is that calling something free does not change what it actually is. Courts look at substance over labels. If guests are paying thousands of dollars for a stay and the property is being used as a rental, the court is not going to accept word games about complimentary nights. Judges are allowed to look at the real-world facts, not just how someone describes them on paper. The judge also mentioned licensing and county ordinances. These rules exist for reasons like safety, zoning, and community impact. A state tourist rooming house license is about health and safety standards. A county rental permit is about local regulation, enforcement, and neighborhood impact. When a court ties an injunction to those requirements, it means the court has already decided that compliance with those rules is not optional. Finally, this case shows something very important about the legal system. Representing yourself does not change the rules. The court holds self-represented parties to the same standards as attorneys when it comes to following orders. You can argue your position, you can appeal, and you can file motions, but you cannot ignore an order and then be surprised when the court enforces it. So, the big takeaway here is simple and practical. If a judge issues an order, especially an injunction, your choices are to follow it exactly or challenge it through the legal process. Trying to invent your own interpretation is not a defense, and missing purge deadlines is not something courts can just overlook. That's why this situation ended the way it did. Not because of a website, not because of a technicality, but because court orders are enforceable, and ignoring them has real consequences. Thanks for watching, and hopefully this breakdown helps make sense of the legal side of what you just saw.